Hello, everybody, and welcome. We're going to wait a minute or so for folks to join us. All right, Portia, let's dive in. I want to welcome everybody to our series entitled Jury Duty Unmasked. It's a really exciting time to be having conversations about jury service. And with the Juror Project, we want to make sure you know all the things that you need to know about this important civic duty. My name is Will Snowden. I am the director of the Juror Project, and I'm going to ask Ms. Porsha-Shaf'on to introduce herself.
Hi, everybody. I am the Robin to Batman. I'm the Deputy Director of the Juror Project, Porsha-Shaf'on Venable. It is a pleasure to be here with y'all tonight.
We got to figure out when your stand-up comedy show is, Portia, because I don't know if people realize, like, we will be in the most serious meetings, and you will hit people with your one-liners, always lightening the mood, which I appreciate. So for those who don't know us, we are the Juror Project, and we were started principally out of an observation of being in the courtroom on regular bases to see the ways in which diversity has been removed from our juries. And we know with the removal of that diversity, there is a removal of fairness from our criminal legal system. And the Juror Project has three main goals. One, we are trying to increase the diversity of our jury panels. And when we say diversity, yes, we're talking about diversity of race, but we're also talking about diversity of perspective, diversity of gender, diversity of age, diversity in every sense of the word, because the research is clear. When we have more diverse juries, we have more fair outcomes. I'm going to ask Portia to share a little bit about why we're starting this series, the Jury Duty Unmasked, in this particular moment.
So, if y'all are like me, y'all are feeling completely frazzled and just really not rooted in sort of what to do about the constant barrage of things that we view as unjust or chaotic. And so jury duty, right, is something that you can have in your toolbox, for when you're feeling like I need to do something, I need to say something, I need to engage in something. We want to give you something tangible, and that is jury duty. But one of the things that we think is lacking is a fundamental understanding of what juror service is and also how you can engage it. So we're going to start remedial tonight. We are going to get to the very bare bones basics of jury duty. We are not here to guilt you about all the times you have reached out to your lawyer friends about how to get out of jury duty. We are not here to guilt you about all the times you Googled how to get out of jury duty. We want to make sure that you are equipped with an understanding of juror service. And we hope that as this series progresses, you will feel very different about jury service and want to engage more.
Thank you so much. We fundamentally believe that an informed juror is a confident juror. And this series is going to be all about informing you as people who will have the potential to serve on a jury. We want to make sure you know kind of what that service entails and what the things you should be made aware of. So tonight's conversation is very focused. We're talking about how juries are created. Specifically, we're talking about this term veneer. Now, the veneer is the term that is used to describe a panel of citizens who have been summoned for jury service, and it is that panel, that representation of people, from which the petit jury is going to be selected. So let me break that down a little bit. In order for you to wind up at the courthouse for jury service, you will have received a summons in the mail. And in order to be on a list to be summoned for jury duty, your jurisdiction can use a variety of lists. We've seen jurisdictions use voter registration, DMV records, tax bills, utility bills, a variety of lists whose principal goal is to gather a fair cross section and representation of the community where that trial is going to take place. So if you're getting a summons in the mail, that means you're probably registered to vote, or you have an active driver's license, or you paid your taxes. Whatever the lists are, they vary throughout the country. That's how you're going to be getting that summons in the mail. Once you get the summons in the mail, you show up. You'll have a date on there. You'll probably participate in some type of orientation, giving you the basics of what your experiences is going to be like. And then in some jurisdictions, you go back home. And you simply call every day to say, hey, do you need me? So like in federal court, you'll call to say the night before, you'll call and say, am I needed for jury service tomorrow? And if they have trials that are taking place, then you'll show up. If they don't, then you'll go to work. In some state courts, you show up to the courthouse and you hang out in the jury lounge. And what you're doing while you're waiting is above you in the courtrooms, there are conversations of whether or not the cases that are scheduled for trial that day are actually going to go to trial. And if they're going to go to trial, then they're going to assemble the veneer, which is a group of people from the jury lounge who are being sent up to the courtroom to participate in jury selection. When we talk about the veneer, that is not the actual seated jury. The veneer represents the group of people from the community who will participate in the conversation of jury selection, where the lawyers will be asking questions, trying to decipher and determine if that person is going to be a good fit for the case or not. And if they're not a good fit for the case, then the attorney might try to remove them. And there's different ways in which jurors can be removed, and then we'll cover that in another topic for jury duty unmasked. Once the veneer is brought into the courtroom, the goal for jury selection is to identify 12 people, if it's a 12-person jury, or 6 people, if it's a 6-person jury, to be essentially chosen to serve on that jury. Now, an interesting thing is you don't actually choose your jurors, you deselect people you don't want. But kind of in the backwards way, you are choosing, you're saying, okay, yeah, this person will be good for our case, or this person won't be good for our case. And then if you don't think they're going to be good, you will use a strike to remove them from the veneer, which means that they won't make it onto the petit jury. I'm using this term petit jury. Sometimes people call it a petite jury, which is probably the appropriate pronunciation. But there's 2 juries that we have in the American criminal legal system. We have a grand jury, and the grand jury has one main goal, and that is to decide whether or not charges should be brought against a person via an indictment. Have you ever heard somebody getting indicted? Well, that means that a grand jury has voted to say, you know, we think there's probable cause for these charges. We're going to vote for a true bill of indictment. So the grand jury starts the cases. The petite jury or the petit jury concludes the cases. Now, for the veneer, in which most of you would be a part of when you get someone for jury service, the veneer creates the pool of individuals from which the jury will be selected. Porsha, what questions do you have for me? Because I know I'm probably missing some things, so I'm looking to you to see things I should be adding, or if you have things to add.
Explain. So you talked a little bit about the grand jury, right? And you talked about probable cause. Probable cause is an incredibly is a legal term, right? So one, can you break that down into its simplest form?
Sure. So the legal definition is going to be a fair probability or reasonable likelihood that the person who was being charged did in fact commit the crime. So we don't quite use percentages, but when we think about kind of levels or degrees of a perhaps burdens of proof, right? We have a hunch. If an officer just has a hunch, you know, that's not enough to stop and talk to you. But let's say they have something called reasonable and articulable suspicion, then they can stop and talk to you. And then above that, we have probable cause. So probable cause is essentially when there's enough information for the members of the grand jury to think, yeah, there's this video surveillance, or there's this testimony from a detective who spoke to a witness, or the witness testified, that gives us enough information to believe that there's a high likelihood or fair probability that this person may have committed the crime in which they're being charged with. The interesting thing about a grand jury proceeding is that it's completely ran by the prosecution. The defense attorneys don't have a role in grand jury proceedings. Now, there are rare occasions, and Porsha, I know you have an example of this, where clients and people who are accused of crime will actually testify during the grand jury by themselves and explain to the grand jurors, like, look, they got the wrong one, and here's why. But the grand jury is a proceeding that happens at the prosecutor's office typically, and the grand jury is not deciding innocence or guilt. They're just deciding whether or not they think enough information has been presented for the charges to be instituted and for the case to begin.
That's actually what I was looking for. That's the language that I was looking for. Oftentimes when family members or even my clients approach me, right, and they're thinking about whether or not, or they've been told by somebody that they should testify in the grand jury, because oftentimes people are misinformed and under the impression that the grand jury decides guilt or innocence. Now, make no mistake about it, right? If you go and testify before the grand jury and the grand jury does not believe there is enough information, and quite frankly, whether or not you testify, if the grand jury does not believe that there is enough information to go forward, then a case is what's called no true bill. So I want to pause here, and I just want our audience to think about each and every time that a prosecutor has put a police involved shooting into the grand jury, and the grand jurors come back without an indictment, aka no true bill, right? Because the grand jury in that particular jurisdiction has decided that there's not enough information to go forward, or they just pro police, or the prosecutor did a raggedy job presenting the case.
It's you see how quickly she went on mute. That's like a little mic drop moment. What's interesting about that is sometimes there is kind of politics played with the grand jury. And if there is a community where the jury knows they're not going to vote for a true bill, meaning they're not going to indict the person, the district attorney in that jurisdiction is going to say, look, I did my job. I presented it to the grand jury, and the community decided not to indict. So there's nothing else that I can do. There's two ways in which individuals can be charged with a crime in our country. One is called a bill of indictment, and the other is called a bill of information. And depending on the jurisdiction that you are in, will determine what method of charging has to be deployed. So, for example, in Louisiana, if you are charged with an offense that is punishable with a sentence that is described as a sentence of life without parole, another way to say that is you are being sentenced to die in prison. It's really not life, it's death in prison. That type of a charge has to be secured by a bill of indictment. But if it's not a life without parole cases, the district attorney can just file charges. They don't have to present it to a grand jury, and it will just simply be a bill of information. So what's the difference with the summons? Do you get a summons for grand jury? Do you participate in jury selection for grand jury? Or do you get a summons for the petit jury? Porsha, can you break that down for us a little bit? When you get a summons in the mail, how do you know if it's going to be grand jury service or petit jury service?
You were picking up what I was putting down, because I was literally just about to ask you to elaborate on how the selection for each, the difference in selection for each juror, right? So, in most jurisdictions, for the grand jury, you receive a summons and you are instructed to report to the grand jury. Now, when you receive the grand jury summons, right, there are no lawyers that are taking part in selecting you. There are no judges that are taking part in selecting you. When you get put on a grand jury, you are simply placed on the jury, and you are in a room, and you are in a room with about 20 to 30 community members, right? And y'all are listening to case after case after case. And remember, right, these cases, this is the prosecutor's arena. The defense attorney and the accused are not allowed to be present unless the accused is is going to testify before the grand jury. And there are very few reasons why a defense attorney would want their client to testify in the grand jury. And that's a different conversation for a different day. But really, what I need you to take away from this conversation about the grand jury is that attorneys and judges have no part in selecting a grand jury. You simply receive a notice and you are called to duty like Batman, right? You get that call, you just answer. That's what it is. And you are then put on a grand jury. And there are often multiple panels of grand juries that are convening at one time, hearing case after case after case after case. In New York, you cannot be prosecuted for a felony unless the case is presented to a grand jury.
Portia, that's the second Batman reference you've made, and I'm noticing you're wearing red. And I see this whole Robin theme is, like a true attorney. Your theme is consistent throughout, from jury selection to closing. You go weave that theory in at least 4 or 5 times. I love it. So back to this topic, we're talking about the veneer, and remember, the veneer is supposed to represent the community. So the jury, the summonses need to be sent out to everybody in the community who is eligible to serve on a jury. Now, most jurisdictions, to qualify to serve on a jury, you got to be 18 years old. You got to be a United States citizen. You have to be a resident of the county or the parish where the trial is taking place. And then some jurisdictions have different rules around whether or not, if you have a felony conviction, you can serve, or if you have a felony conviction, you can't serve. Before we get into how people are excluded from the veneer, Porsha, are there any other lists that have crossed your radar that have been used to add people to the list to curate those summonses?
Absolutely. Most veneers, as you've already stated, get curated from people who are registered to vote, and people who have a driver's license or have some registration with the Department of Motor Vehicles, right? But that assumes a lot, right? Because not everyone is registered to vote, not everyone has a driver's license. And so there has been a lot of conversation and advocacy to make juries diverse, to have courtrooms across the country pull from other types of lists. Those lists include public housing, those lists include public benefits, right? We don't just want to pigeonhole ourselves and say only people who vote and only people who have a driver's license are qualified to serve. There are different people from all across the country that, despite not having a driver's license or being registered to vote, are more than qualified to serve on juries. But before we move on, Will, you talked about something that I just want to take a step back to, right? And we talked briefly about the veneer being a reflection of the community, right? And what's always interesting about that is how we think about community, right? And when we think about jurors coming from the accused community, we naturally assume that that community is where the juror is from, right? And that, in fact, is rarely ever the case, right? I am from the Northwest Bronx, right? And if I was accused of a crime, there's absolutely no guarantee, and it's incredibly unlikely that people from my block are going to be called to serve on a case for me. So when we're thinking about what community is in the creation of a jury of our peers, what often happens is that there will be people called from the Bronx, right, to serve as jurors on my case, but not necessarily from my community. And if we think about different communities and the personalities of different communities, it gets a little dicey, right? I think about the West Bank in New Orleans and how it's different from the East, right? I think about even different sections, how the French Quarter is different from Uptown in New Orleans, right? And the same thing goes for New York City. If there's anybody on here from Brooklyn, right, we know that it is way different from the Bronx. If there's anybody from Harlem on here, we know that that community is way different from the Bronx and Brooklyn. And don't even get me started on Staten Island.
We won't. But I do appreciate um, lifting up the reality that when we talk about a jury of your peers, that can mean one thing to us, and to the law, it means something else, right? So the law doesn't really define who your peer is. It just says it has to be from the community and the jurisdiction from where the crime is alleged to have taken place. The law is really, really terrible as it relates to this notion of ensuring that a person who is going to trial has someone that is similarly situated to them on the jury. So, for example, if I am an indigenous person and I'm accused of a crime in a parish in Louisiana, and it is a predominantly white parish in Louisiana, and when the jury comes in, there are no other indigenous people on the jury. By looking at it, you would say, oh, he doesn't have any peers as it relates to his identity of being an indigenous person of my ethnicity. And the law says that that's fine. The law says that you are not guaranteed a particular juror on your case. The only thing that you are guaranteed is to select your jury from a fair and representative sample or a fair cross section of the community. And that fair cross section is what the veneer is supposed to represent. Now, I disagree with what the law says, right? And that's part of our work to really kind of push the law to update itself because it's not consistent with the things that we are seeing in 2025 as compared to when we inherited this jury system from common law England, right? And so being in this space of having conversations about our criminal legal system, we have one of two choices. We can either accept the system in which we have inherited, or we can work towards changing it.
Well, we have a question, and the
Mhm.
question is how can we advocate for our communities to expand the list, or do we have a say?
It's a great question. You have to look at the statute in your state. And if you can find the statute in your state that talks about the source lists, that's going to be the name, the source lists. Sometimes in the statute, it will say voter registration, DMV records, or any other list that is approved by the clerk of court or the jury commissioner, whatever it might be. If it has that language that says, or any other lists that are approved by some official, then the community can lobby and advocate for that individual to add lists so that we are capturing a more representative sample. But if you are in a jurisdiction where you pull up the law for the source lists to develop the juries, and it just says voter registration, DMV records, period, then what you have to do, that's a whole legislative campaign where you have to amend the law or update the law to either specifically add certain lists like utility bills or tax bills, whatever it might be, or advocate that the language, kind of the general language of any other list that's approved to be added, to be included in the new law.
One thing that I want to head note, if we have any lawyers on this call, is I really want to advocate for movement lawyering, right? And as lawyers who are the individuals that have the power to get up in the courtroom and speak, we really do need to rely on the community and listen to the community more. Oftentimes, particularly, in the criminal defense world, the lawyers that are practicing in the courthouse are not necessarily from the communities. And I want to urge lawyers, right? When you are up there and you are selecting your jury, I know that trial is anxiety provoking, but I want to encourage you and empower you to really look back into the audience and ask audience members questions about the different communities that people are saying they're from, right? I want you to turn, right, and speak to your client and ask your client, right? I've never tried a case where I didn't turn to my client. I mean, I practice in the Bronx, and I know New York City pretty well. But if I didn't know a certain area of Brooklyn, I would turn to my client and say, you know, what's that area like? And if there is no one, right, from a community that is at the very least similar to the one that my client is from, it's also incumbent upon me, right, to advocate for that as well. So I appreciate the question, but I also really think that it's incumbent upon us as lawyers, particularly those that are in more disenfranchised communities, to really engage the communities more. It will elevate your defense exponentially.
I have a friend who's watching and they just text me, what can a lawyer do if the jury veneer comes in and it doesn't look like the community? There's a legal challenge and it's called a fair cross-section challenge. And so let's say you're in New Orleans and New Orleans is about 60% Black, 30% white, 5% Latino, 3% Asian. And let's say the jury comes in and it's all Black people. There are no white people, there are no Hispanic people, there are no Asian people, right? That's not a fair cross section. So what you can do is you can raise a fair cross section challenge to say, hey, Your Honor, this is not what the community looks like. And there's three things, it's called the Duren test. There's three prongs that you as an attorney have to satisfy. First, you have to demonstrate that the group of people that are missing from your veneer are what are called a distinct group. Second, and by distinct group, I mean, based on gender or based on race are the typical categories. The second prong is you have to demonstrate that the proportionality or the the representation of that distinct group on the jury is not proportional to their representation in the community. So if we're talking about an all-Black jury in New Orleans, and there's no white people, there's no Hispanic people, there's no Asian people, what you would say is that the underrepresentation of the white people, the Vietnamese people, or the Asian people, the Hispanic people on the jury is 0, but here go their numbers in the community. And then thirdly, and this is where most of the fair cross-section challenges fail, is you have to demonstrate that the underrepresentation of that distinct group is caused by systemic exclusion, meaning there's something inherent about how that jurisdiction is administering the jury service process that is excluding that particular distinct group. So that's the challenge that you can make, and you make that before jury selection is actually kicked off, right? You're making that when you see, hey, there's an obvious distinct group that is missing from the veneer, and I want to raise a challenge to it because this veneer is supposed to be a fair cross section. But we know it's not a fair cross section because there's an obvious group of people, that distinct group, that is missing from that panel of jurors.
And I just want to head note for any other lawyers on the call. It is that language that you should be using, because that's what the law says. You should literally be saying you're challenging whether or not this is a fair cross section. Well, I know that question got your juices flowing, Will, because I know how you feel about fair cross sections and those challenges.
Yes, indeed. And my frustration is that the test that the Supreme Court has provided is unwinnable. And so it kind of just sets people who are accused of crime up for failure to help ensure that a fair cross section is being provided. And we have a solution, that's cooking, that hopefully one day Porsha and I can be arguing in front of the Supreme Court for, to say, hey, you got to change this, and here's why. I want to transition a little bit, Porsha, to who is excluded from the veneer. And I talked a little bit about people with felony convictions, felony disenfranchisement. is this reality that there are some states, a little under half of the states in our country, do not allow people with felony convictions to serve on a jury. And the federal system does not allow people with felony convictions to serve on a jury. And I just want to talk a little bit about that impact, right? If we believe that our criminal legal system is supposed to, I'm not saying it necessarily does, but it's supposed to be a system in which we hold people accountable. They pay their debt to society. They are rehabilitated, right? When they come home, they should have their rights restored. But when we continue to punish them, we're actually elongating their sentence, right? So if I'm
Absolutely.
sentenced for 10 years, why am I still being punished after I've served my time and I've quote unquote paid my debt to society? So one harm that is created with felony disenfranchisement, it is actually continuing punishment that really, is beyond what society has talked about being an appropriate quote unquote sentence for the crime that may have been committed. But also, we are perpetuating a myth that formerly incarcerated people and people with felony convictions don't care about safety in their communities, or we are wrongly assuming that when people with felony convictions serve on a jury, that they're automatically going to vote not guilty. When I was involved in helping change the law in Louisiana, there was a state representative who was like, why would we let, and this is his language, not mine, why would we let these cons back onto a jury box? Or why would we let these felons serve on a jury? Right? People in my community would never support this, so I can't support it. And what was interesting is I was able to respond and say, these people with felony convictions were just awarded the right to vote for you as a state senator, for their judges, for their district attorneys 2 years ago, or 3 years prior to when we were bringing the legislation in Louisiana. I said, so you actually supported that bill restoring the voting rights to people with felony convictions. And so if they are capable enough to vote for you as their representative, why can't they be capable enough to be part of the conversation of holding a fellow neighbor accountable or finding that they should not be held accountable because they didn't commit a crime? So we have a very kind of distorted perspective of people with felony convictions and the perspective that they might not have, as if they don't want to live in safe communities, as if they don't want to have a justice system that is fair, as if they don't have a role in having a conversation of what accountability should look like. And that's just not the case, right?
And they know better
Um,
than anybody.
yeah, and when we, have been a lot of folks that have done research on this particular issue, hosting mock juries, and have identified the role that people with felony convictions have served during the deliberation process. And one study references that the people with felony convictions were actually the most conservative jurors in the deliberation room, right, for these mock jury studies. It also references the value that the people with felony convictions add to the deliberation process. So if somebody has been convicted of a particular crime and perhaps is familiar with police investigation, they can say, look, when I was convicted of this, they had boom, 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 right? They don't have any of this in this case, so something's not right. So there's a
Right.
perspective that is really, really valuable that can add to the deliberation process. And so thinking about the harm that comes with not allowing people with felony convictions to serve on juries, we're continuing punishment unnecessarily, right? Research says when you restore people's rights, they are less likely to recidivate or to commit another crime. So thinking about how we are integrating them back into our communities is something that we should be mindful of. And then secondly, we're again not facilitating this fair cross section. If my community has people with felony convictions as part of my fair cross section for the veneer, I should be able to have a right to have access to those folks on my jury.
What's wild too is that in just about every other aspect in our life, we value experience,
Yeah.
except in this respect, right? And it is
Mm,
wild that one can go through one of the most arduous experiences one can go through as a member of the community, and that's the carceral system, right?
hmm.
And then you come out and you're told that your experience is not valuable.
Yeah.
But before we continue to move forward, I actually do want to take two steps back. We've had some more guests join this conversation. Welcome,
Okay.
y'all.
Yeah.
One thing that I wanted to just revisit really quickly for those that have just joined, can you remind folks what the term veneer means?
Absolutely. So we're having a deep dive conversation about this term veneer. And veneer represents the group of community members who have showed up for jury service, and they are assembled to go and participate in jury selection. So you get a jury summons in the mail, you show up to court, you've gone through orientation, you're hanging out in the jury lounge. The jury commissioner gets a call from a judge and says, hey, we need 50 jurors, we're about to go to trial. So the jury commissioner will assemble 50 people who have showed up. Let's say there's 300 people who have showed up. They'll assemble 50 people. They'll send them up to the courtroom to begin to participate in jury selection. That group of 50 people is supposed to represent a fair cross section of the community. It's supposed to be a representative sample of what the community looks like. That group of 50 people is called the veneer. And that's the term that we use to describe the group of people from whom the jury is selected from.
We also have a fair cross section challenge question from my homegirl, who's an incredibly dope lawyer in the Bronx, Yasmin. So, what Yasmin asks is, does your client's race matter when making a cross section challenge?
A great question, Yasmin. It does not. The Supreme Court has said that the race of the accused person does not matter as it relates to making a fair cross-section challenge. And if we think about why that makes sense, it's because what your community looks like is what your community looks like. And that does not have any influence or any bearing on the race of the person who is accused of a crime. So if you are in I don't know the demographics of Kings County, or outside, I won't even try. But like, think about, we know, I'll just stick with Orleans Parish because that's what I know. Orleans Parish is 60% Black, 30% white, 5% Latino, 3% Asian. If a fair cross section and the veneer is being developed, the veneer should closely match the percentage of the demographics of the community, both in terms of race and in terms of gender. So the race or gender of the person on trial does not matter in your ability to make a fair cross-section challenge.
Thank you.
Mm-hmm.
So we talked about the fact that people with felony convictions in some jurisdictions can't serve. I want to talk a little bit about what does qualify you as a juror generally, and then I
Okay.
want to talk briefly about exemptions. And don't be getting out
Mm.
your pens and papers to figure out how you can be exempt. But generally, what qualifies you to be a juror in any state is that you have to be a US citizen, you have to be 18 years or older, you have to reside generally in the jurisdiction. So, for example, just using New York City as a marker, if I'm accused of a crime in the Bronx, my jurors have to come from the Bronx. If I'm accused of a crime in Brooklyn, my jurors have to come from one of the counties in Brooklyn, right? And the same with each borough. You have to be able to speak and understand English, and you can't have any disqualifying mental or physical conditions. And when we're talking about disqualifying, right? Oftentimes, in many cases, you obviously have to be able to hear, right? Or have some mechanism in place that would allow you to be able to hear testimony. You have to have decent vision, right? That would allow you to be able to look at photographs, videos, or whatever is being proffered to you as evidence. And in some jurisdictions, as Will has already had noted, you cannot be convicted of a felony. You cannot have a felony conviction. That actually disqualifies you from serving on a jury in some jurisdictions. One of those jurisdictions is New York, unfortunately. Shout out to Jury of Our Peers, who's working, the coalition is working to get that changed here in New York. But one of the things that automatically exempts you across the country is if you're older than 70 years old. If you are active military and you are deployed, lawyers, you are not exempt from juror service. Okay, you can be fair and impartial. Even you, criminal defense attorneys. Um, and so I'll just leave it at that for right now, unless you have a question.
We have a question coming in about how do you protect the jury's vote in favor or against a bill? And um, this question might be referring to a bill of indictment, is
Hmm.
what I'm thinking through. As it relates to protect the jury's vote, if there's a certain threshold, so for an indictment, it does not have to be unanimous. Typically, it's like 2/3. And the size of a grand jury can
Quorum.
range
Mhm.
from like 16 to maybe 20. It depends on the jurisdiction
Right.
in terms of the size. So it has to be probably a majority of that number of jurors for the grand jury. When you ask the question like, how do you protect the jury's vote? Um, it's pretty well written in law. If the jury is voting for a no true bill or voting not to indict, then that kind of ends the matter for the case being initiated at that stage. If they vote for a bill of indictment, that is going to initiate the prosecution. So every state has a code of criminal procedure, and it has a specific kind of clarification as it relates to how cases or how prosecutions can be instituted. And as was mentioned, it's either going to be a bill of information or a bill of indictment. The jury's vote to decide whether or not to indict somebody is protected by the statutes articulated in the criminal procedure for that jurisdiction.
And just so you are aware, the if a grand jury decides there is not enough information to go forward, right? Essentially what that grand jury is doing is holding the prosecutor to their burden, right? And what they are saying is what you're not going to do is bring in some raggedy case, some lying cop, and have us, move this case forward. Now, one thing that people don't realize though is if a grand jury decides, right, that there is not enough information to go forward, the prosecution can try again
Yep.
and again, right? And what people often forget is, again, right, when we have these police involved murders and the grand jury decides that there is not enough information to go forward, the prosecutor can absolutely bring that case again with more evidence. It happens all the time when they really want to, right? But what a grand jury is doing when they are voting no true bill is holding the prosecutor to their burden, which is don't bring us some raggedy case and or some
Mhm.
lying witnesses.
And what they're saying is there's no probable cause, right? That's effectively what they're saying. Now, I know there are some people who are thinking, well, if the jury is saying no indictment, why isn't that double jeopardy? Can you break down, Portia, in terms of why a grand jury voting not to indict somebody doesn't have jeopardy attached to prevent them from being considered to be charged in the grand jury a second time?
Yes. So, and I apologize. Can you repeat the last part of that question?
Yeah, so the concept of double jeopardy, why doesn't it apply to the decision the jurors are making in the grand jury?
So basically, what the prosecutor is doing, right, is they're essentially saying that this individual has committed some act of harm, right? And it's somewhat gamesmanship. I'm just going to name it, right? It's somewhat
Hmm.
gamesmanship. And what prosecutors often try to do, because I, as the defense attorney, will ultimately get the transcript, what they try to do is present as little evidence as possible in an effort to get a bill of indictment. And again, when community members band together and they say, there's not enough probable cause for this case, then the prosecutor then is allowed to go out and try to get more information, more evidence, or present more information, present more evidence that would then give them that probable cause to allow the grand jurors to to vote in their favor, which would be a bill of indictment. Did that make sense?
It does. Can you tell us what is double jeopardy?
Sure. So, I mean, we all know it by its very commercial name, right? Which is, or the commercial concept, which is you can't be tried for the same crime twice, right? But it depends. It truly, truly, truly depends. There are a lot of loopholes. So, for example, if a case goes to trial, right, and a jury cannot reach a verdict, then that case can be tried again now. And we are going to be talking about this later on when we start talking about your power to nullify. So tune in. But we are going to talk about this concept of a juror's verdict not being disturbed. So when a jury actually reaches a verdict, right, the concept of jeopardy, double jeopardy, has attached. Now, another way that this can sort of play out is if you are a defense attorney on the state in the state, and you are a defense attorney in the prosecutor, excuse me, in the federal jurisdiction, right? If you are prosecuted for possessing a gun on the state level, you can also, and at the same time, be prosecuted for having a gun, right, in the federal courts. So one of those jurisdictions are gonna have to give up the case, right? Because you cannot be charged with the same crime in multiple places in the same state.
Hmm.
So, and more times than not, it's the federal government that usurps the state.
So what I'm hearing is double jeopardy is this premise that you can't be tried for the same crime twice if the jury has actually reached a verdict in your case. And then secondly is you can be charged with the same crime by the state government and the federal government because those are two separate, the legal term would be separate sovereigns. Those are two separate entities. We have state government, we have federal government, and they can each bring their own separate conversations. We have a couple comments, one from Dr. Farrow sharing that in New York State, if you have something that's called a certificate of relief, you can be qualified to serve on a jury with a felony conviction. And I know there's some really good work in, Porsha had already referenced the Jury of Our Peers bill. That's not what, is that what it's called? Remind me, Porsha, because I'm forgetting. Yeah, Jury of Our Peers bill. We had some good traction last year, and it sounds like we might be able to take a second crack at it this year. And then another question is that there's a question about a Brady violation. Isn't it close to a Brady violation or on the fence of withholding information? I imagine this question might be relating to when a jury votes not guilty in one case, if that information isn't shared or conveyed with the other jurisdiction, like the federal jurisdiction that wants to bring forth the case. And if I'm not getting your question right, Miranda, I do apologize. I'll share an example of a case where I had somebody who was charged who went to trial in federal court, was found not guilty, and then they brought charges in state court because they couldn't, because he was found not guilty in federal court. I knew, the client knew, he was like, look, I already went to trial on this in federal court. And when you use the term Brady violation, for the folks that aren't familiar with that term, Brady is a case that references that the state has an obligation to turn over to the defense all of the evidence and information that either inculpates or exculpates the client, meaning that they have to turn over all of the police reports and information that they're trying to use to demonstrate that the person has committed a crime, or if there's information that demonstrates that the person may not have committed the crime, they have to turn that over as well. And so as it relates to the verdict in a trial, that wouldn't necessarily qualify as discovery that needs to be turned over via the Brady versus Maryland case. But it is an important question to at least think through how that information could be used as insight for the new case if it does come up.
And two things. One, I want to highlight what Dr. Farrow said, which is that a certificate of relief of disabilities can qualify an individual in New York State with a felony conviction to serve. That is correct. But the one thing that I want to note for folks is that a certificate of relief from disabilities is discretionary. So, one, you have to ask for it, and it has to actually be granted. And judges have discretion in whether or not they are willing to grant those. But Dr. Farrow, thank you for elevating that, and that is correct. Another thing with respect to Miranda's statement or question is at the onset of a case, right? You would think that if there's any indication that the individual who was arrested didn't commit a crime, or that the individual who was arrested may have had a lawful reason for doing what they do, right? It is in reality, right? You would think that prosecutors would put forth that information as early as possible. They don't always. They don't
Yeah.
always. They don't always.
Yeah. I just want to highlight one more topic before we close out, and that's as it relates to juror pay and how that can be a barrier for service. So again, we're thinking about the veneer, and as a reminder, the veneer is the group of people that get sent, that has showed up to the courtroom or the courthouse for jury service. Then they get assembled in a group of 25 or 50 or however many people it is. They get sent up to the courtroom where the lawyers will ask them questions. The veneer is supposed to be this representative sample of the community. We know that diversity is removed from that veneer panel because some people just literally cannot afford to take time off of work and serve on juries. Now, some jurisdictions pay you little, they pay you peanuts, they don't really give you any money at all. Other jurisdictions might pay a little bit more. I want to highlight for folks that are tuning in this pilot program out of California and San Francisco called Be the Jury. And this pilot program focused on financially supporting low to moderate income folks who are trying to serve on the jury and paying them $100 a day for their jury service.
Shout
And
out to
we
Brendan Woods.
absolutely, Alameda County coming through.
Shout
Um,
out to Brendan
we
Woods.
we have some interesting data that is coming out that's demonstrating the benefit of paying people $100 a day. So imagine if you are a wage worker and your boss is like, listen, if you don't show up, you don't get paid. And so you're like, well, I got to go to work because I got to provide for my family. If that's your decision, you're not going to be inclined to go serve on a jury knowing that you're only getting paid $10 for the day, right? That's nothing. But if there's a program that is actually compensating folks $100 a day, then we're removing one of these barriers to service, which is weeding out people from a lower socioeconomic status and providing them the access to the power in that jury box, which everybody should have access to. I just want to highlight three statistics or three data points from this Be the Jury pilot program in California. The first thing is that 84% of participants in the Be the Jury program said that they were able to serve because they were getting paid that $100 a day. The second thing, 90% of the participant that received the juror stipends, they were able to serve on the jury for more than just one day. And then thirdly, 60% of the participants were people of color. So if I get back to one of the goals of the Juror Project, remember I mentioned at the top that we were trying to increase diversity of jury panels. That's diversity of race, diversity of perspective, diversity of gender, diversity of age, diversity in every sense of the word, because the research is clear. When we have more diversity, we have more fairness. This effort to pay people more is helping increase the diversity of these jury panels, which is only going to improve the fairness of these trials that are taking place. With that, Porsha, I'm going to invite you to close us out, give us some final thoughts, and let us know what we might be happening next month.
So I actually want to thank everyone who joined us. I'm super hyped to be talking to y'all, super hyped to be in community with y'all. So thank you for our first in a series of Jury Duty Unmasked. Please look forward to many other topics that we're gonna be unpacking. Um, Attorney conductive voir dire, judge conductive voir dire, your power to nullify, right? What your role as jurors can look like. I'm super excited for this breakdown um, going forward.
Thank you so much. If you aren't already, and since you're tuned in, maybe you already are, we want you to join us on Instagram, on Facebook. We have a YouTube channel. We're trying to make sure that people know everything they need to know about jury service, right? We're trying to unmask or unveil the mystery behind jury service. We have been seeing so much more attention being directed towards jury service, and we want to be your source of trusted and valuable information about this important civic duty. So follow us on your different handles. We do have a newsletter. You can go to the jurorproject.org and sign up for our newsletter so you can stay up to date with the information that we're passing on. Thank you for joining us this evening, and we really hope that not only you join us for the next one, but you bring a friend as well. Thank you and have a good night.
Absolutely. Have a wonderful night, y'all.
Bye.